Okay, in Illinois versus Gates, 1983, Justice Rehnquist delivered the opinion of the court. A chronological statement of events usually introduces the issues at stake. Bloomingdale, Illinois, is a suburb of Chicago located in DuPage County. On May 3, 1978, the Bloomingdale Police Department received by mail an anonymous handwritten letter which read as follows. This letter is to inform you that you have a couple in your town who strictly make their living on selling drugs. They are Sue and Lance Gates. They live on Greenway off Bloomingdale Road in the condominiums. Most of their buys are done in Florida. Sue, his wife, drives their car to Florida where she leaves it to be loaded up with drugs, and Lance flies down and drives it back. Sue flies back after she drops off the car in Florida, May 3rd. She is driving down there again, and Lance will be flying down in a few days to drive it back. At the time Lance drives the car back, he has the trunk loaded with over $100,000 in drugs. Presently, they have over $100,000 worth of drugs in their basement. They brag about the fact that they never have to work and make their entire living on pushers. I guarantee if you watch them, carefully, you will make a big catch. They are friends with some big drug dealers who visit their house often. Lance and Susan Gates, Greenway in condominiums. The letter was referred by the chief of police of the Bloomingdale Police Department to Detective Mader, who decided to pursue the tip. Mader learned from the office of the Illinois Secretary of State that an Illinois driver's license had been licensed or issued to one Lance Gates residing at the stated address in Bloomingdale. He contacted the confidential informant whose information of certain financial records revealed more recent address for the Gates, and he also learned from a police officer assigned to O'Hare Airport that L. Gates had made a reservation on Eastern flights 245 to West Palm Beach, Florida, scheduled to depart from Chicago on May 5th at 4:15 p.m. Mader then made arrangements with an agent of the Drug Enforcement Administration for surveillance of the May 5 Eastern Airlines flight. The agent later reported to Mader that Gates had boarded the flight and that federal agents in Florida had observed him arrive in West Palm Beach and take a taxi to the nearby Holiday Inn. They also reported that Gates went to a room registered to one Susan Gates, and that at 7 a.m. the next morning, Gates and an unidentified woman left the motel in a Mercury bearing Illinois license plates and drove northbound on an interstate frequently used by travelers to the Chicago area. In addition, the DEA agent informed Mader that the license plate number on the Mercury registered to a Hornet station wagon owned by Gates. The agent also advised Mader that the driving time between West Palm Beach and Bloomingdale was approximately 22 to 24 hours. Mader signed an affidavit setting forth the foregoing facts and submitted it to a judge of the Circuit Court of DuPage County together with a copy of the anonymous letter. The judge of that court thereupon issued a search warrant for the Gates residence and their automobile. The judge, in deciding to issue a search warrant for the Gates residence and their automobile, the judge, in deciding to issue the warrant, could have determined that the modus operandi of the Gates had been substantially corroborated. As the anonymous letter predicted, Lance Gates had flown from Chicago to West Palm Beach late in the afternoon on May 5th, had checked into a hotel room, registered the name of his wife, and at 7 a.m. the following morning had headed north accompanied by an unidentified woman out of West Palm Beach on an interstate highway used by travelers from South Florida to Chicago in an automobile bearing a license plate issued to him. At 5:15 a.m. on May 7th, only 36 hours after he had flown out of Chicago, Lance Gates and his wife returned to their home in Bloomingdale, driving the car in which they had left West Palm Beach. Some 22 hours earlier, the Bloomingdale police were awaiting them, searched the trunk of the Mercury, and uncovered approximately 350 pounds of marijuana. A search of the Gates home revealed marijuana, weapons, and other contraband. The Illinois Circuit Court ordered suppression of all these items on the ground that the affidavit submitted to the circuit judge failed to support the necessary determination of probable cause. Just writing this down because it's procedural context that their circuit court motion to suppress for lack of probable cause to believe that the Gates automobile and home contained the contraband in question. This decision was affirmed in turn by the Illinois Appellate Court and by a divided vote of the Supreme Court of Illinois. The Illinois Supreme Court concluded, and we are inclined to agree, that standing alone, the anonymous letter sent to the Bloomingdale Police Department would not provide the basis for a magistrate's determination that there was probable cause to believe contraband would be found in the Gates car and home. The letter provides virtually nothing from which one might conclude that its author is either honest or his information reliable. Likewise, the letter gives absolutely no indication of the basis for the writer's predictions regarding the Gates' criminal activities. Something more was required. Then, before a magistrate could conclude that there was probable cause to believe that contraband would be found in the Gates home and car. The Illinois Supreme Court also properly recognized that Detective Mader's affidavit might be capable of supplementing the anonymous letter with information sufficient to permit a determination of probable cause. In holding that the affidavit, in fact, did not contain sufficient additional information to sustain a determination of probable cause, the Illinois court applied a two-pronged test derived from our decision in Spinelli v. United States. The Illinois Supreme Court, like some others, apparently understood Spinelli as requiring that the anonymous letter satisfy each of the two independent requirements. Before it could be relied on. According to this reveal the basis of knowledge of the written letter, the particular means by which he came by the information given in his report. Second, it had to provide facts sufficiently establishing either the veracity of the affiant's information or, alternatively, the reliability of the informant's report on the particular case. The Illinois court, alluding to an elaborate set of legal rules that have developed among various lower courts to enforce the two-pronged test, found that the test had not been satisfied. First, the veracity prong was not satisfied because there was simply no basis for concluding that the anonymous person who wrote the letter to the Bloomingdale Police Department was credible. The court indicated that corroboration by police of details contained in the letter might never satisfy the veracity prong, and in any event could not do so, as in the present case only innocent details are corroborated. In addition, the letter gave no indication of the basis of the writer's knowledge of the Gates' activities. The Illinois court understood Spinelli as permitting the detail contained in the tip to be used to infer that the informant had a reliable basis for his statements, but it thought that anonymous letter failed to provide sufficient detail to permit such an inference. Thus, it concluded that no showing of probable cause had been made. We agree with the Illinois Supreme Court that the informant's veracity, reliability, and basis of knowledge are all highly relevant in determining the value of his report. We do not agree, however, that these elements should be understood as entirely separate and independent requirements to the requirements to be rigidly exacted in every case, which the opinion of the Supreme Court of Illinois would imply. Rather, as detailed below, they should be understood simply as closely intertwined issues that may usefully illuminate the common sense practical application whether there is probable cause to believe that contraband or evidence is located in a particular place. This totality of the circumstances approach is far more consistent with our prior treatment of probable cause than is any rigid demand that specific tests be satisfied by every informant's tip. Perhaps the central teaching of our decisions bearing on the probable cause standard is that it is a practical, non-technical conception. In dealing with probable cause, as the very name implies, we deal with probabilities. These are not technical, they are factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. Our observation regarding particularized suspicion is also applicable to the probable cause standard. The process does not deal with hard certainties, but the probabilities. Long before the law of probabilities was articulated as such, practical people formulated certain common sense conclusions about human behavior. Jurors, as fact finders, are permitted to do the same, and so are law enforcement officers. Finally, the evidence thus collected must be seen and weighted not in terms of library analysis by scholars, but as understood by those versed in the field of law enforcement. As these comments illustrate, probable cause is a fluid concept, turning on the assessment of probabilities in particular factual contexts, not readily or even usefully reduced to a neat set of legal rules. Informant's tips doubtless come in many shapes and sizes from many different types of persons. Rigid legal rules are ill-suited to an area of such diversity. One simple rule will not cover every situation. Moreover, the two-pronged test directs analysis into two largely independent channels, the informant's veracity and reliability and his basis of knowledge. There are persuasive arguments against according these two elements such independent status. Thus, they are better understood as relevant considerations in the totality of circumstances analysis that traditionally has guided probable cause determinations. A deficiency in one may be compensated for in determining the overall reliability of a tip by a strong showing as to the other or by some other indicia of reliability. If, for example, a particular informant is known for the unusual reliability of his predictions of certain types of criminal activities in the locality, his failure in a particular case to thoroughly set forth the basis of his knowledge surely should not serve as an absolute bar to a finding of probable cause based on his tip. Likewise, if an unquestionably honest citizen comes forward with a report of criminal... God, there's a lot of footnotes here. They're talking about Jones versus United States. Held probable cause to search petitioner's apartment was established by an affidavit based on an informant's tip. Unnamed informant claimed to have purchased narcotics. So he had an interaction with them, right, on prior occasions. And then Rugendorf versus United States, 1964. So the first one was 1960. 1964, Rugendorf, Court upheld in magistrate's determination there was probable cause to believe that certain stolen property that would be found in petitioner's apartment. The affidavit submitted to the magistrate stated that certain furs had been stolen, and the confidential informant who previously had furnished confidential information said that he saw the furs so he saw them in their home. Moreover, another confidential informant also claimed to be reliable, stated that they had stole them. Police reports indicated that petitioner had been seen in their company, and the third informant stated that petitioner was a fence for them. Okay. And then Kerr versus California, 1963, we held that information within the knowledge of officers who searched the Kerr's apartment provided them by a probable cause to believe drugs would be found there. The officers were aware that Juan Murphy had previously sold marijuana to a police officer. The transaction had occurred in an isolated area. So that's the source. To say that this coincidence of information was sufficient to support a reasonable belief that the officers at Kerr was legally in possession of marijuana is to indulge in understatement. Now, there's a Florida versus Harris, 2013 case in the footnotes on page 132. No more for dogs than for human informants is a rigid approach to determining reliability called for. in this case, unanimously rejecting the state court's holding that the state must, in every case, present an exhaustive set of records showing a drug detection dog's reliability, rather undergates flexible common sense standard, and all things considered approach is needed. The court should allow the parties to make their best case consistent with the usual rules of criminal procedure, and the court should then evaluate the proffered evidence to decide what all the circumstances demonstrate. If the state has produced proof from controlled settings that a dog performs reliably in detecting drugs and the defendant has not contested that showing, then there should be probable cause. So I'm just going to underline that part. If, in contrast, the defendant has challenged disputing the reliability of the dog overall or the particular alert, then the court should weigh the competing evidence. The court then concluded probable cause existed in the instant case as the state showed the dog had successfully completed 2 drug detection courses and maintained his proficiency through weekly training exercises, while defendant's evidence purporting to show 2 false start alerts to his vehicle might be attributable to the defendant, a regular meth user, transferring the odor to the door handle. Just look at other notes. This note's about the Spinelli test. So, there's at least 4 more pages of this case. Going into deep detail, I think the outcome of another case. So it'll be about 6 more pages in this case. So the activity, which if fabricated would subject him to criminal liability, we have found vigorous scrutiny in the basis of his knowledge unnecessary. Conversely, even if we entertain some doubt as to an informant's motives, his explicit and detailed description of alleged wrongdoing, along with the statement that the event was observed firsthand, entitles his tip to greater weight than might otherwise be the case. Unlike a totality of circumstances analysis, which permits a balanced assessment of the relative weights of all the various indicia of reliability and unreliability attending an informant's tip, the 2-pronged test has encouraged an excessively technical dissection of informant tips, with undue attention being focused on isolated issues that cannot sensibly be divorced from the other facts being presented to the magistrate. We also have recognized that affidavits are normally drafted by non-lawyers in the midst of haste of a criminal investigation. Technical requirements of elaborate specificity, once exacted under common law pleading, have no proper place in this area. Likewise, search and arrest warrants long have been issued by persons who are neither lawyers nor judges, and who certainly do not remain abreast of each judicial refinement of the nature of probable cause. The rigorous inquiry into the Spinelli prongs and the complex superstructure of evidentiary and analytical rules that some have seen implicit in our Spinelli decision cannot be reconciled with the fact that many warrants are quite properly issued on the basis of non-technical common sense judgments of laymen applying a standard less demanding than those used in more formal legal proceedings. Likewise, given the informal, often hurried context in which it must be applied, the built-in subtleties of the 2-pronged test are particularly unlikely to assist magistrates in determining probable cause. Similarly, we have repeatedly said that after the fact scrutiny by courts of the sufficiency of the affidavit totally just lost my spot. Should not take the form of de novo review. A magistrate's determination of probable cause should be paid great deference by reviewing courts. A grudging or negative attitude by reviewing courts toward warrants is inconsistent with the Fourth Amendment strong preference for searches conducted pursuant to the warrant, and courts should not invalidate warrants by interpreting affidavits in a hyper-technical rather than a common sense manner. If the affidavits submitted by police officers are subjected to the type of scrutiny some courts have deemed appropriate, police might well resort to warrantless searches with the hope of relying on consent or some other exception to the warrant clause that might develop at the time of the search. In addition, the position of a warrant by officers conducting an arrest or search greatly reduces the perception of unlawful or intrusive police conduct by assuring the individual whose property is searched or seized of the unlawful authority of the executing officer his need to search and the limits of his power to search. Reflecting this preference for the warrant process, the traditional standard for review of an issuing magistrate's probable cause determination has been that so long as the magistrate had a substantial basis for concluding that a search would uncover evidence of wrongdoing, the Fourth Amendment requires no more. We think reaffirmation of this standard better serves the purpose of encouraging recourse to the warrant procedure and is more consistent with our traditional deference to the probable cause determinations of magistrates than the two-pronged test. Finally, the direction taken by decisions following Spinelli poorly reserves the most basic function of any government, to provide for the security of the individual and his property. The strictures that inevitably accompany the two-pronged test cannot avoid seriously impeding the task of law enforcement. If, as the Illinois Supreme Court apparently thought, the test must be rigorously applied in every case, anonymous tips would be of greatly diminished value in police work. Ordinary citizens, like ordinary witnesses, generally do not provide extensive recitations of the basis of their everyday observations. Likewise, as the Illinois Supreme Court observed in this case, the veracity of persons supplying anonymous tips is the hypothesis largely unknown and unknowable. As a result, anonymous tips seldom could survive a rigorous application of either of the Spinelli prongs. Yet, such tips, particularly when supplemented by independent police investigation, frequently contribute to the solution of otherwise perfect crimes. Where are we? While a conscientious assessment of the basis for crediting such tips is required by the Fourth Amendment, a standard that leaves virtually no place for anonymous citizens, informants is not. For all these reasons, we conclude that it is wiser to abandon the two-pronged test established in our decisions in Aguilar and Spinelli. In this, actually, I'm going to go directly to the footnote, which obviously is going to expand on the two-pronged test as a reminder. Footnote 11, whether the allegations submitted to the magistrate in Spinelli would, under the view we now take, have supported a finding of probable cause, we think it would not be profitable to decide there are so many variables in the probable cause equation that one determination will seldom be useful precedent for another. Suffice to say that while we in no way abandon Spinelli's concern for the trustworthiness of informers and for the principle that it is the magistrate who must ultimately make a finding of probable cause, we reject the rigid categorization suggested by some of its language. That actually was just an omission, a truncation, redaction. So, in its place, we reaffirm the totality of the circumstances analysis that traditionally has, I'm just going to underline that, totality of the circumstances analysis that traditionally has informed probable cause determinations. The task of the issuing magistrate is simply to make a practical common sense decision whether, given all the circumstances set forth in the affidavit before him, including the veracity and basis of knowledge of persons supplying hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. And the duty of a reviewing court is simply to ensure that the magistrate had a substantial basis for concluding that probable cause existed. We are convinced that this flexible, easy applied standard will better achieve the accommodation of public and private interests that the Fourth Amendment requires than does the approach that has developed from Aguilar and Spinelli. Our earlier cases illustrate the limits beyond which a magistrate may not venture in issuing a warrant. A sworn affidavit of an affiant that he has cause to suspect and does believe that liquor illegally brought into the United States is located on certain premises will not do. Nathanson v. United States, an affidavit must provide the magistrate with a substantial basis for determining the existence of probable cause, and the wholly conclusory statement issue in Nathanson failed to meet this requirement. An officer's statement that affiants have received reliable information from a credible person and believe that heroin is stored in a home is likewise inadequate. Aguilar v. Texas, as in Nathanson, this is a mere conclusory statement that gives the magistrate virtually no basis at all for making a judgment regarding probable cause. Sufficient information must be presented to the magistrate to allow the official to determine probable cause. His actions cannot be mere ratification of bare conclusions of others. In order to ensure that such an abdication of the magistrate's duty does not occur, courts must continue to conscientiously review the sufficiency of affidavits on which warrants are issued. But when we move beyond the bare bones affidavits present in cases such as Nathanson and Aguilar, this area simply does not lend itself to a prescribed set of rules like that which had developed from Spinelli. Instead, the flexible common sense standard articulated in Jones and other cases better serve the purposes of the Fourth Amendment's probable cause requirement. Justice Brennan's dissent suggests in several places that the approach we take today somehow downgrades the role of the neutral magistrate because Aguilar and Spinelli preserve the role of magistrates as independent arbiters of probable cause. And some of that is omitted. That quote is omitted. Quite the contrary, we believe in this case. Nothing, in our opinion, in any way lessens the authority of the magistrate to draw such reasonable inferences as he will from the materials supplied to him by applicants for a warrant. Indeed, he is freer than under the regime of Aguilar and Spinelli to draw such inferences, or to refuse to draw them if he is so minded. The real gist of Justice Brennan's criticism seems to be a second argument somewhat at odds with the first. The magistrates shown to be restricted in their authority to make probable cause determinations by the standards laid down in Aguilar and Spinelli, and that such findings should not be authorized unless there is some assurance that the information on which they are based has been obtained in a reliable way by an honest or credible person. However, under our opinion, magistrates remain perfectly free to exact such assurances as they deem necessary, as well as those required by this opinion in making probable cause determinations. Justice Brennan would apparently prefer that magistrates be restricted in their findings of probable cause by the development of an elaborate body of case law dealing with the veracity prong in the Spinelli test, which in turn is broken down into two spurs: the informant's credibility and the reliability of his information, together with the basis of knowledge prong in the Spinelli test. That such a labyrinth body of judicial refinement bears any relationship to familiar definitions of probable cause is hard to imagine. So nobody highlighted that, but I feel like that's a really good explanation of these tests. Right there is like application of the test. And I might even read it again of the test, but they're old tests, they're invalidated. So sure. That such a labyrinth body of judicial refinement bears any relationship to familiar definitions of probable cause is hard to imagine. Justice Brennan's dissent, which we'll get to, also suggests that words such as practical, non-technical, and common sense, as used in the court's opinion, are but code words for an overly permissive attitude towards police practices in derogation of the rights secured by the Fourth Amendment. Fidelity to the commands of the Constitution suggests balanced judgment rather than exhortation. The highest fidelity is achieved neither by the judge who instinctively goes furthest in upholding even the most bizarre claim of individual constitutional rights, any more than it is achieved by the judge who instinctively goes furthest in accepting the most restrictive claims of governmental authorities. The task of this court, as of other courts, is to hold the balanced role, and we think we have done that in this case. Our decisions applying the totality of the circumstances analysis outlined above have consistently recognized the value of corroboration of details of an informant's tip by independent police work. Our decision in Draper v. United States, however, is a classic case on the value of corroborative efforts of police officers. There, an informant named Hereford reported that Draper would arrive in Denver on a train from Chicago on 1 or 2 days, and that he would be carrying a quantity of heroin. The informant also supplied a fairly detailed description of Draper and predicted what he would be wearing: a light-colored raincoat, brown socks, and black shoes, and would be walking really fast. Hereford gave no indication of the basis for this information. On one of the stated dates, police officers observed a man matching this description exiting a train arriving from Chicago. His attire and luggage matched the Hereford's report, and he was walking rapidly. We explained in Draper that by this point of his investigation, the arresting officer had personally verified every facet of the information given him by Hereford, except whether petitioner had accomplished his mission and had the 3 ounces of heroin on his person or in his bag. And surely, with every other bit of Hereford's information being thus personally verified, the officer had reasonable grounds to believe that the remaining unverified bit of Hereford's information that Draper would have the heroin with him was likewise true. The showing of probable cause in the present case was fully as compelling as that in Draper. Even standing alone, the facts obtained through the independent investigation of Mater and the DEA at least suggested that the Gates were involved in drug trafficking. In addition to being a popular vacation site, Florida is well known as a source of narcotics and other illegal drugs. Lance Gates' flight to Palm Beach, his brief overnight stay in a motel, and apparently immediate return north to Chicago in the family car, conveniently awaiting him in West Palm Beach, is as suggestive of a prearranged drug run as it is of an ordinary vacation trip. In addition, the magistrate could rely on the anonymous letter, which had been corroborated in major part by Mater's efforts, just as had occurred in Draper. The Supreme Court of Illinois reasoned that Draper involved in informant who had given reliable information on previous occasions, while the honesty and reliability of the anonymous informant in this case were unknown to the Bloomingdale police. While this distinction might be an apt one at the time the police received the anonymous letter, it became far less significant after Mater's independent investigative work occurred. The corroboration of the letter's predictions that the Gates would be in Florida, that Lance Gates would fly to Florida on the next day or so, and that he would drive the car north toward Bloomingdale, all indicated, albeit not with certainty, that the informant's other assertions also were true. Because an informant is right about some things, he is more probably right about other facts. Spinelli, Supra, White, J, concurring, is the citation for that, including the claim regarding the Gates' legal activity. This may well be the type of reliability or veracity necessary to satisfy some view of the veracity prong of Spinelli, but we think it suffices for the practical common sense judgment called for in making a probable cause determination. It is enough for purposes of assessing probable cause that corroboration through other sources of information reduce the chances of a reckless or prevaricating tale. thus providing a substantial basis for crediting the hearsay. Prevaricating? Prevaricating is the word. V-A-R-I-C-A-T-cat-I-N-G. Prevaricating. Finally, the anonymous letter contained a range of details relating not just to easily obtained facts and conditions existing at the time of the tip, but to future actions in third parties ordinarily not easily predicted. The letter writer's accurate information as to the travel plans of each of the gates was of a character likely obtained from the gates themselves or from someone similar with their not entirely ordinary travel plans. If the informant had access, it was not unlikely that he also had access to reliable information of the gate's illegal activities. Of course, the gate's travel plans might have been learned from a talkative neighbor or travel agent under the two-pronged test developed by Spinelli. The character of the details in the anonymous letter might well not permit a sufficiently clear inference regarding the letter writer's basis of knowledge, but as discussed, previously, probable cause does not demand the certainty we associate with formal trials. It is enough that there was a fair probability that the writer of the anonymous letter had obtained his entire story either from the gates or someone they trusted, and corroboration of major portions of the letter's predictions provides just this probability. It is apparent, therefore, that the judge issuing the warrant had a substantial basis for concluding that probable cause to search the gate's home and car existed. The judgment of the Supreme Court of Illinois, therefore, must be reversed. Justice White, concurring in the judgment, begins on page 139. There are extremely long footnotes to this case, which I might very well go into, but Justice White has a 3-page concurrence, if I recall. Brennan and Marshall joined dissenting on page 42. Stevens and Brennan dissent on page 145 before getting to Maryland and Pringle on page 146. So we're looking at 8 pages of dissent, concurrence, and dissenting opinions. I'm going to read those to myself, taking out from the footnotes United States v. Harris, 1971, plural opinion. The informant said that he had purchased illicit whiskey from defendant for 2 years, most recently within the past 2 weeks, and had often seen defendant get whiskey for him and others in a certain building. The plurality opinion concluded that because people do not lightly admit a crime and place critical evidence in the hands of police in the form of their own admissions, such admissions carry their own indicia of credibility, sufficient at least to support finding a probable cause to search when, as here, the basis of such knowledge was also indicated, as almost inevitably will be the case when there is such an admission. The 4 dissenters objected. So that's another case with the same last name, Harris. And I see no new cases in the footnotes.